Hello students, welcome to Ashish Polala classes. Today in the present lecture of CPC, I am going to discuss with you section number 17 of CPC. In the last video, we had studied section number 16 of CPC, and in that lecture, we had seen that the civil suit in relation to the immovable property. That the civil suit in relation to immovable property or in relation to the movable property, which movable property is actually under distraint or attachment of an authority. That type of civil suit must be instituted before the court within the territorial limit of which that property is situated. That means to say, if that civil suit in relation to the immovable property, then the civil suit must be instituted before the court within the territorial limit of which that immovable property is situated. Whereas if in relation to the movable property, which is actually under distraint or attachment, any civil suit is required to be instituted, then that civil suit must be instituted before the court within the territorial limit of which that movable property is actually under distraint or attachment. So this was something about section number 16. But now very important question arises. And what is that question? What will happen if one immovable property for which the dispute is related situates within the jurisdiction of more than one court? I want to repeat, what will happen if the immovable property for which the dispute is related situates within the jurisdiction of not one court, if it situates within the jurisdiction of more than one court? So in this case, section number 17 provides the answer to this question. What is stated in section number 17 of CPC? Let us see. According to section number 17 of the code, where a suit, that means to say where a civil suit relates to obtaining the relief respecting immovable property, or where a suit relates to compensation for wrong to immovable property. So it is very clear here that this section number 17 only talks about the dispute in relation to immovable property. It do not deal with the suit in relation to any movable property. Okay, I want to repeat it again. Where a suit relates to obtaining relief respecting immovable property or compensation for wrong to immovable property. And if that immovable property, it is very important, and if that immovable property situates within the jurisdiction of different courts, that means to say if the immovable property situates within the jurisdiction of more than one court, then where to file the civil suit? Then the civil suit in relation to that immovable property may be instituted in any of the court within the local limit of whose jurisdiction any part or any portion of that immovable property is situates. But before filing that civil suit before any court, the suit must be within the pecuniary jurisdiction of such court before which the civil suit is going to be instituted. So let us recall section number 17. It says that where a suit relates to the obtaining relief respecting immovable property or compensation for wrong to immovable property, And if that immovable property situates within the jurisdiction of different courts, then the civil suit in relation to that immovable property may be instituted in any of the courts within the local limit of whose jurisdiction any portion of the immovable property situates, provided that the suit must be within the pecuniary jurisdiction of such court. So, in this way, we have seen that the object of section 17 is to avoid multiplicity of suits before the different courts, and it provides the one forum in relation to the entire relief in respect of a property, which property falls within the jurisdiction of more than one court. So it is very important to see if this section 17 of CPC was not inserted in CPC, then what may happen? According to section number 16, you have to file the suit before the court within which the immovable property is situated. And if one single property falls within the jurisdiction of different court, then in the absence of section number 17, the civil suit has to be filed before the different courts. But section number 17 avoid this type of situation, and it avoid the multiplicity of suits before the different court, and it provides only single court in which you can claim the entire relief for a single property, which single property falls within the jurisdiction of more than one court. So to make it simple, let us take an example in which section number 17 can be applied. In our Kapurthala district, there is a village Dayalpur, some part of which falls within the jurisdiction of Kapurthala district, whereas some part of this village falls within the jurisdiction of Jalandhar district as well. And suppose if any immovable property of this village Dayalpur situates within the jurisdiction of both Kapurthala and district court, and if any dispute is made out of that immovable property, then where we should file the civil suit in relation to that immovable property, whether the civil suit has to be filed in Kapurthala or whether the civil suit should be filed within the civil court of Jalandhar. The answer of this question is very simple. It can be instituted before any court. That means to say, if there is immovable property of village Dayalpur situates within the jurisdiction of both Kapurthala and Jalandhar district, and if any dispute arises in respect of that immovable property, then the civil suit in relation to that property can be instituted either before the civil court of Kapurthala or the civil court of Jalandhar. So in this way, we have completed our section number 17. And if any of you wants to get notes of this video, then notes of this video are available in the description, where I have provided a link of my blogs, ashishpodalaclasses.blogspot.com. So stay with me. I will meet you in section number 18 of CPC. Thank you very much.